So, my agenda for today's session is boilerplate clauses and key clauses in joint venture agreements, shareholder agreements, and M&A related contracts. Feel free to raise your hand and ask questions anytime during the session. First point, boilerplate clauses. So what is boilerplate clause? What is non-boilerplate clause? Very simply put, boilerplate clauses are clauses which are not affected by the nature or purpose of contract, which are not affected by the commercials of the transaction, which are more or less standard contractual clauses used for any contract. For example, a notice clause, whether it is a sale deed, a joint venture agreement, and a business purchase agreement, any sort of agreement, notice clause will pretty much be the same, and it will contain certain standard points like address for giving notice, details of person to whom the notice should be given, time period within which the notice given will be deemed as received, method of giving notice, whether you can give only by courier or only by email or a combination. In case of international parties, whether only courier and airmail is allowed, whether even any other methods are allowed. Assignment clause, irrespective of the nature of contract, assignment clause will pretty much say either the assignment is permitted with consent, without consent, etc. Similarly, severability clause, it won't change much. It will still say that clauses which, if any court regards as invalid, will be severed or separated from the contract, and the rest of the contract will continue to be applicable. So, boilerplate clauses mainly means clauses which are not affected by the nature or purpose of contract. They are more general or generic in nature.
Achromic Point.